Ms. Christine Rideout.
Thank you, Chief Justice, Justices. It is Alberta's position that prosecutorial liability should not be extended to Ms. Feason's claims by third parties or accused persons for the reasons set out in our factum. And I hope to address 3 points in my oral submissions this morning. The first are the compelling policy concerns that arise when prosecutorial liability is expanded. And they are particularly acute in my submission when we're dealing with Ms. Feason's claims. The first is the diversion of prosecutors from their duties. This court has recognized that the public interest is not served when prosecutors are unable to focus on their primary responsibility, the fair and effective prosecution of crimes. The second concern is the chilling effect that such liability will have on the decision-making of prosecutors. Again, this court has confirmed that the public interest is undermined when prosecutorial decision-making is influenced by considerations extraneous to a prosecutor's role as a quasi-judicial officer. In my respectful submission, these considerations have led this court to only recognize 2 exceptions to civil liability in the past 30 years. Those were canvassed by counsel for the Attorney General of Ontario, cases of malicious prosecution and cases of charter damages for wrongful non-disclosure. And both of those are further restricted to restrict their availability. Expanding prosecutorial liability to Ms. Feason's claims by third parties virtually eradicates these carefully constructed exceptions and opens the door to an unlimited number of claimants alleging harm based upon the multitude of decisions made by prosecutors in the course of prosecutions. This becomes readily apparent when one considers the reputational harm alleged in this case. As we know, the credibility and reliability of Crown witnesses is a live issue in the vast majority of trials. Trial judges routinely provide reasons explaining why the evidence of Crown witnesses is believed or not believed. Those reasons are often repeated in the media or in subsequent court proceedings, regardless of the party involved. The reasons for disbelieving a witness can be uncomplimentary, and no doubt in cases will reflect poorly on the reputation of those witnesses, including complainants, civilian witnesses, probation officers, expert witnesses, and police officers. Expanding prosecutorial liability to third parties and third-party Ms. Feason claims based upon the trial judge's credibility and reliability findings will and can only result, in my respectful submission, in the diversion of prosecutors from their duties and the chilling effect on their decision-making. And I'll explain that because it brings me to my second point, which is the impact that this will have on the Crown's unique role and duties as ministers of justice. The Crown, or the role of Crown prosecutors, must always be to achieve just results, and their duties include acting impartially and laying before the trier of fact the evidence they consider to be credible. Extending prosecutorial liability to third-party Ms. Feason claims undermines this unique role and duties by encouraging prosecutors to act for the benefit of third parties. Rather than impartially assessing the credibility of evidence and communicating that assessment with candor to the court, prosecutors facing the risk of civil liability when a third party's reputation is impugned or may be impugned will be encouraged to make decisions designed solely to rehabilitate the reputation of those third parties. One can easily envision scenarios where Crown prosecutors will be subject to multiple actions arising from a single prosecution at any stage of the proceeding and regardless of the outcome. The conduct that I've described in terms of encouraging Crown prosecutors to act for the benefit of third parties and their reputations will no doubt expose those same prosecutors to corresponding civil actions by the accused. This court has confirmed and proved that prosecutors who conduct prosecutions for the benefit of third parties act for an improper purpose inconsistent with their roles as ministers of justice. And that brings me to my final point, the negative impact that extending liability will have on the the liberty, security, and fair trial interests of the accused, given the inevitable delay that will follow. As I've noted, the vast majority of trials involve the credibility and reliability of Crown witnesses. The proposition that a prosecutor must halt a trial whenever there is a possibility of an adverse credibility finding so that they may bolster a witness's credibility or risk of civil liability, will inevitably result in delay. That delay not only jeopardizes the accused's right to be tried within a reasonable time, it also denies justice to victims, their families, and the public as a whole. The increased potential for civil liability will also encourage prosecutors to engage in risk assessments for the endless number of decisions that they must make in the conduct of a prosecution, and to refrain from making the difficult and often unpopular decisions.
Thank you very much.
Thank you very much, Chief Justice.